Member Heather Roy.
Thank you, Mr Speaker. I rise to speak to this urgent debate on behalf of the ACT Party, and I'd like to say, to start with, that it would be nice to see some facts involved in this debate, but perhaps that's too much to be asked for. Labour, Mr Mallard, when he first got up to speak, used this as an opportunity to attack the government. He seemed more upset, I have to say, that the Prime Minister hadn't acknowledged the contribution of the Labour Party in getting the Rugby World Cup here than he does about the provisions of the urgent debate itself. And Minister Joyce, in response, seemed to take the chance then to have a swipe back at Trevor Mallard using 2006 press clippings, amongst other things. The Green Speaker, although he did use the opportunity to publicise much more broadly the Green Party public transport policy, did in fact get to the crux of the matter, and I was very pleased to see that he had acknowledged Dean Knight's contribution, his paper Nationalisation of the Rugby World Cup Party Central. This is the only summary that I've seen, the only comprehensive narrative on the issue that I've seen that does actually get to the crux of the matter of this urgent debate. Anyone listening, of course, could be much more taken, I think, with the political bickering opportunities that have been taken in this debate than actually an examination of the facts involved, which do largely revolve around the two laws put in place, MEMA and the Rugby World Cup Empowering Act. So this action, I would contend, Mr Speaker, is much more about perception than it is about reality, and I think it does bear some examination. What exactly is it that the Minister has done? The announcement made by Minister McCulley, what exactly does this mean? The Rugby World Cup Empowering Act was passed late last year to provide for special procedures for regulatory approvals for Rugby World Cup activities and liquor licences. Of course, the Independent Rugby World Cup Authority was constituted to consider these applications. Now, the legislation itself allows for application and the process it follows, but it also provides for an even more expedited process, and I quote, in circumstances of urgency that for good reason were not foreseen. A much higher threshold was required. Now, a different and more expedited process was provided for, as I've said, but rather than being determined by the Rugby World Cup Authority, as some seem to think is the case, the authority itself only assesses the application and makes a recommendation to the Minister for the Rugby World Cup. There is no obligation to subject the application to a participatory process. It's merely a handing on once it's assessed. The decision about whether the approval should be granted then falls not to the authority itself, but to the Minister responsible, Minister McCulley. He will consult, or is obliged to consult, with the Minister for Economic Development and any other relevant ministers. He must take into account, but is not to be bound by, the recommendation of the Rugby World Cup Authority, and his decision is final at that point. And that's it. These are the only special powers under the Rugby World Cup Act, and we shouldn't lose sight of the fact, notwithstanding the events that have sparked this debate today of last Friday. The Minister's role, it should be noted, is a reactive role as ultimate decision-maker once an urgent application is made, and then only after the Independent Rugby World Cup Authority has scrutinised it. So the Rugby World Cup Empowering Act, thankfully, doesn't give the Minister the ability to take control of the waterfront or to run parties on that waterfront. A jolly good thing that is too. I don't think any of us would want to see that. So what is it that's happening now that the application's been made? The applications presently being made urgently are conjoint applications for the Ministry of Economic Development and Auckland Council's events team. It seems that these applications were already in process of being prepared collaboratively before the Minister's announcement. And the fast-track approvals currently being sought, I have to say, are largely mundane. So the application is a joint one between the MED and Auckland Council's events unit. MED is seeking permission to use the Captain Cook Wharf for Fanzone events, and the Auckland Council is seeking to extend the existing liquor licence over the wharf. And so that will be passed now on to the Minister to decide. The Rugby World Cup Authority is considering both applications following a brief period for public submissions and is holding a public hearing today. So the problems, what exactly are the problems arising from this? Well, listening to the debate today, I think that probably nobody's very clear what the problems are, but from an ACT perspective, this is how we see things. This isn't about taking control, and as I've already said, that is a good thing. This isn't about taking control of the waterfront or taking control of any parties. Rather, it's a perception that the government is doing something. So on the other side, I contend that the government has made a meal of this when in fact very little, other than has already been talked about, is happening. This is to do with the Minister's special power to approve urgent applications under the Rugby World Cup Act, and it does raise a potential issue at law. It's a basic principle of administrative law that decision makers exercising statutory powers must keep an open mind and must not predetermine the outcome of applications. That ensures applications are properly considered and there is no conflict of interest. So there is a question, keeping that in mind, Mr Speaker, a live question about whether Minister McCulley's directives and public statements mean he has compromised his ability to personally consider the urgent applications. And my Green Party colleague raised that very pertinent point in the speech he has just delivered. Now, in such circumstances, there is provision for something else to happen. Under Section 7 of the Constitution Act 1986, another minister is able to exercise that power. And one of the things that I think this House should be interested in, Mr Speaker, in account of transparency and accountability, is to see if that does in fact happen. And again, my Green Party colleague raised that matter. Looking more broadly, what is more worrying, I think, of the issues that have been raised as a direct result of the events on the Auckland waterfront of last Friday afternoon, what is more worrying is the fact that the government does appear to be saying publicly that it has no confidence in the new Auckland Council to handle these waterfront events. If it has no confidence, this indeed is worrying, not just for the Rugby World Cup, but I would contend well beyond, and this is something that we certainly will be looking at. The other thing that I just would finish by saying, Mr Speaker, is that we as legislators, we politicians as legislators, need to be very careful before putting in place legislation that does give wide-ranging powers to a government or to ministers. We need to be very careful about empowering legislation and the power that it does give, particularly to individuals. So I hope, Mr Speaker, that I've injected a little factual information into this debate and taken it away slightly, if only temporarily, away from a he said, she said debate about who's doing the best job of getting the World Cup here and how it's being run. Because that, Mr Speaker, isn't what this debate should be about. It should be around the provisions in place in law already and how those are being put into effect.